Hello. Welcome to Mentoring with the Masters. My name is Jennifer Kuyrkendall. I'm the Third Circuit representative for the Young Lawyers Division Board of Governors. Today we have the pleasure of hearing from Joe Bodiford. Joe is board certified in criminal trial law, as well as board certified in criminal trial advocacy by the National Board of Trial Advocacy. Our first video with Joe will address client issues and ethics in criminal cases. Joe, welcome. Thank you for joining us here today.
Thank you very much for having me.
Great. Let's start immediately. When you first have an initial consultation with a client on a criminal matter, what are some of the things that you need to look out for?
Well, I think that for a young practitioner who's first venturing into the criminal practice, there's two things they should be very mindful of. The first thing is the scope of the representation. Unfortunately, with what we do, we find that sometimes our clients who are in criminal cases tend to have multiple issues going on and multiple issues that can arise after the initial issue has started. As I had to tell one client one time, please stop referring to your crime spree as the trilogy. But I think it's that young attorneys have to be very careful to get the scope very clearly delineated as to what the representation will be. Because you don't want to have a client go out and have other issues pop up as the first case is pending and expect you to represent him or her on those cases. You'll have to very clearly tell them in the representation agreement, this is it. If you have anything else, we'll have to enter into new agreements on those. The other thing that I think is very important is with prospective clients that come in for consultations, you'll find that many of them are shopping. They're looking at various lawyers. They don't fit with a particular personality. They're looking for the right price. And you'll get people that come in and you may never see them again. It's very important that you have something established in your initial consultation, I suggest it be in writing, that says, if you don't retain me, I do not represent you. We don't want people walking out with some expectation based on your conversation with them that that's my attorney. And that can happen. And the bar looks at it subjectively from the standpoint of the client. So what I suggest to everybody is make sure you put it in writing, have them sign, unless and until you have a retainer agreement with me, I do not formally represent you and I will not be taking any action on your behalf.
In addition to that, is there anything else you should be mindful of?
Well, the biggie is competence. Diligence in representing someone is certainly one thing. The bar wants us to be diligent when we're representing people, but you can be diligent in a matter and not be competent in it. And a lot of young lawyers, when they venture out into the criminal practice, they want to take a case, maybe perhaps for money, and they might take the case at a very low price just to get it in. They also may be looking for a way to make a name for themselves. So they want to take a big, heavy-duty case like a murder or a drug trafficking or a federal case even. And the question then becomes, are they really competent to be able to handle that case? Competence can be gained, certainly, throughout the course of your practice, and it is a practice because we never get it right. We continually have to practice. But I think that young attorneys have to be very leery of taking a case that they may not be able to handle. If you're going to take a case that you think is above your head, reach out to a more seasoned practitioner, call one of the old dogs, and ask for assistance. And I think you'll find that most older attorneys are very willing to help you get the experience you need.
What about conflicts? What are some of the general types of conflicts that you see?
When a person comes in and they're sitting across the table from you, you got to be mindful of whether or not you can actually represent that somebody based on who they know or who else may be involved in the case. No person can serve two masters. And clearly, you'll find in criminal practice, as you know from your years as a prosecutor, we tend to come up with some interesting sayings, but today's defendant might be tomorrow's witness, and there's some people that live at the courthouse. So you got to be careful of conflicts, and certainly the thing you cannot do is if you have two people that come in that are charged with the same crime, I tell people as a general rule, no, don't even try to find a way to represent them both. If you think you can do it, make sure you get a written waiver from both of them. But I'd say that's one of the biggest pitfalls as far as the major conflict in criminal cases. For some reason, our clients never seem to want to commit crimes by themselves. So this happens quite a bit.
And they feel compelled to talk about it.
They always feel compelled to talk about it. So those are the big issues.
All right. What about any other bits of advice that you might have for young lawyers?
In criminal cases, somebody's liberty is at stake. It's not about money. It's about time away from families, time sitting in a prison, time sitting in a jail. And it's a life-changing experience. Make sure you're competent, and if you don't know the answers, research it and get help from an older attorney.
All right, thank you, Joe. And that concludes this video for Mentoring with the Masters. Thank you for watching.